Good morning and a very warm welcome to this virtual event, The Impact of COVID-19 on Education and Social Care. I'm Catherine from Jigsaw in Thornbury and I'm the Operations Manager, and I should be here this morning alongside Steven Baylis. I'd like to wish you a warm welcome and obviously hope you can get plenty out of it, and I'll hand you over to Steven Baylis.
Thank you, Catherine. Good morning. Yes, so I'm Steven Baylis. I'm an Associate Solicitor in the Public Law and Human Rights team in the Birmingham office, and I specialise in education and social care matters. So I'm just going to give you an update on the current position in respect of education and social care as it stands. What I should say from the outset is that I wrote these slides and I finished them on Wednesday evening, and by Thursday morning they were somewhat out of date because the government, of course, published a new set of guidance, quite a few documents yesterday, which I haven't unfortunately had a chance to incorporate into the slides, but I will work through some of the key points as they arise in respect of what this means for education as we go forward. In terms of the legislation and the guidance as it was at the end of Wednesday, we're looking at the ones that are listed on the slides at the moment. So primarily, of course, the Children and Families Act 2014 and the Special Educational Needs and Disability Regulations 2014. Currently, these have been modified. So we have the third notice from the Secretary of State for Education to modify the Section 42 duty in respect of provision in the HCP, and we'll look at that in more detail, as well as the regulations that have been amended by the Special Educational Needs and Disability Coronavirus Amendment Regulations 2020. We've also then, of course, got the guidance that the government has published. So the guidance is on that side is one part, but there's of course now a lot more for everybody to get to grips with. And in terms of the social care, the Children Act, the Chronically Sick and Disabled Persons Act, the Care Act, and all the relevant guidance, including Care Act guidance in terms of the Care Act easements, which the government has published as well, all need to be considered. So lots and lots of documentation, lots of things to think about, and so we'll just work through some of the key points this morning. Okay, so from the 1st of June, it was for certain year groups to return to school. So nursery reception year 1, year 6. From the 15th of June, it's year 10 and 12. As we know, the government guidance from yesterday and the announcements confirmed that all pupils will be expected to return to school in the autumn term. So we need to think about that a bit further. In terms of the current position, there is mention for children who are children of vulnerable children or children of critical workers who have continued to be able to attend education throughout the period of time, and vulnerable children is defined as on the slide there. So a child in need with the child in need plan, child protection plan, or looked after child, or those who have an EHCP or assessed as otherwise vulnerable. The government guidance had recognised and currently still recognises, of course, that children, younger children can't be expected to remain 2 metres apart, and there are obviously practical difficulties with managing certainly social distancing within younger age groups and also within certain groups, depending on the level of needs that a child or young person might have, and then of course the provision that's required for them. The government has been encouraging children who are eligible to attend school, but it has been clear that parents will not be fined for non-attendance at this current time. What that then looks like as we move forward is something else we need to think about. And as it stands, the safeguarding duties have remained the same. So in accordance with the Keeping Children Safe in Education statutory guidance, there's been no change to safeguarding duties. So of course those are a paramount consideration for anybody working with any child or young person, especially those who might be vulnerable. So if we just begin with the Special Educational Needs and Disability Coronavirus Amendment Regulations, that affected and changed all stages of the EHCP process for the period of the 1st of May to the 25th of September. This is the current deadline for any of the amendments, and there can be an extension of that. Of course, that date comes from the Coronavirus Act. When we look at the guidance from the government yesterday, there may not be a need for a national extension of any of these parts, but there is the possibility of localised amendments to the Section 42 duty, which we'll consider, and so we need to think about whether there'll be any extension of any of the regulations as well as we move forward. Prior to the 1st of May, all duties remained the same as per the Children and Families Act and the SEND regulations, so any of the amendments that I'm going to talk about now only took effect from any decisions within this period from the 1st of May, and so that's important for anybody who was expecting certain actions to have been completed before the end of April that maybe still are outstanding, because if there is no reason why those could not have been completed in the statutory time limit as was applicable before, then that will still be the case. This applies, and the regulations being amended applies from, say, just the 1st of May and decisions that arise from that. And it applies where the coronavirus exception applies, which is that the reason for not being able to do something must be for the reason related to or to the incidence or transmission of the coronavirus. And where that applies, the steps which would usually be taken within a set period of time must be taken as soon as reasonably practicable. So just look at the key changes that have been amended by the regulations. And so I've listed these on the slide and we'll just quickly run through them. So the decision whether to carry out an EHC needs assessment, that's changed. So normally a local authority must decide within 6 weeks of receiving a request whether it will carry out the assessment. So that now is as soon as reasonably practical. That obviously can cause some difficulties with anybody making a request at this stage, because we don't know how long the local authority will need to respond to that. The cooperation duty on other bodies in terms of an EHC needs assessment, ordinarily they must comply with the request within 6 weeks of receiving it, and that most usually went to social care or to healthcare, particularly if there's a need for maybe therapies to be considered within an EHC needs assessment for a possibility within an EHCP. That was before 6 weeks and now is as soon as reasonably practical. There sometimes have been difficulties even with the 6 week time limit in actually getting that information back in the timescales that are required, but now without the force of the regulation in respect of that, obviously makes it more difficult and hard to enforce if there is a delay in getting the information, and obviously that can put a strain on anybody needing to get support and assistance from bodies who need to cooperate with an EHC needs assessment process in order to ascertain what the correct provision is. That's going to cause obviously delays in terms of securing EHCPs and getting provision in place. So the decision whether to secure an EHCP following assessment has moved. So the ordinary position is that 16 weeks after the date of the request, which is effectively the equivalent of 10 weeks after an EHC needs assessment has been identified as being required, then the local authority would need to decide whether to issue an EHCP. Naturally, if there's a delay getting information, particularly if there's a delay getting other bodies to cooperate and provide that information, that can have a knock-on effect here. And so that's obviously relevant to when the local authority could, as soon as reasonably practicable, secure an EHCP following the assessment. Same with the local authority sending the finalised EHCP out. That's relevant here again, because the ordinary timescale is at 20 weeks from the date of the request, which is the equivalent then of 4 weeks after the decision to secure an EHCP. That EHCP must be finalised delays throughout the process will obviously impact on whether that can be secured and when it can be secured. And again, all we've got there to rely on is as soon as reasonably practical. Annual reviews of EHCPs. The ordinary position is, of course, that every EHCP must be reviewed within every 12 months, and so it can be reviewed more often, but within every 12 months, that's now again as soon as reasonably practical. I think in practice, lots of annual reviews have still been able to be carried out via remote means, which we can look at a bit further as we go through the slides. But again, there's that absolute duty is again sort of watered down, if you like, to as soon as reasonably practicable. As with the information following annual reviews and decisions whether to amend following annual review, and of course this will be relevant to future rights of appeal to the tribunal, because decisions following annual review, either a decision not to amend or amending an EHCP, and then with the final EHCP, both give rise to appeals to the tribunal. So there's a concern about needs, provision and placement that needs potentially the tribunal to resolve it. There can be a delay in getting that right of appeal. Just some further changes as well in terms of so timeframes for amending annual review, amending EHCPs following annual reviews. That has changed from the normal period of 8 weeks to, again, as soon as reasonably practical. Decisions whether to carry out a reassessment, again, have been extended beyond the normal 15 days of receiving the request, and so has the considerations as to mediation and getting a mediation certificate, and the ordinary position here was that must be done within 3 working days. And the timeframes for complying with tribunal orders have also been altered. So the tribunal, when it makes orders as to what local authorities must do, has prescribes a set time limit by which those actions must be taken. Those now have all been amended to as soon as reasonably practicable, which for anybody who is maybe transferring school or moving between provision or needs some updating of their EHCP to secure some provision, that can obviously cause some delay here. So of course there have been a large number of changes, but the reasons for not complying with the ordinary timeframes must be for the reasons of incidence or transmission of coronavirus. So this is for individual decisions, and there needs to be consideration as to why it's impractical to comply with the time limit. So consideration there from local authorities as to why it's impractical to comply, what steps have been attempted to do so, and then what does that mean for when that decision or action can be communicated and made. So this is not just a blanket policy, this is an individual decision, and it needs to be set in the specific circumstances, and this will vary up and down the country and within local authorities as well as to individual decisions based on all the circumstances of an individual child or young person's EHCP or other request in relation to EHCPs that will affect the timescale. So there's no fixed point, but again, there needs to be a consideration as to why, in relation to the incidence or transmission of coronavirus, there's a delay. So the guidance recognises how delays can be reduced and considers new ways of working. So this can include local authorities establishing virtual advisory panels, possibly gathering information by assessments in a setting consistent with the guidance regarding reducing transmission of coronavirus. So assessing with some distance, or potentially wearing face masks. These are all considerations as to how you can make sure that you can gather the information safely that would limit the reason for delays and certainly the length of delays. And can we give information by a phone or virtual meeting? We're on Teams now, and Teams and Zoom are all being used, and lots of other platforms throughout this period to get information, and as well as, of course, the phone. And there's no reason that those ways can't be attempted. And it's very, very important to remember that local authorities just can't apply a blanket approach to decision making in this respect. So decisions which don't explain the specific circumstances and just say, well, we can't, for in such limited terms, would not be acceptable in accordance with the amended regulations. In terms of what hasn't changed, still a substantial amount remains as it was. So this includes parents having at least 15 days to respond to a draft EHCP. And you might think, well, why is this not changed when all the other timescales for local authorities has changed? But the original wording and current still the wording of the regulations is that parents have at least 15 days to respond. So if further time is required, and that can be provided and requested by parents, there's no reason that that can't be amended. So just because that has stayed the same in law doesn't mean that it's absolutely fixed, and further time can be requested beyond the 15 days to respond. And of course that might be very necessary for some people who have a lot of different commitments at this point and different considerations that they need to factor into their lives, which could delay them being able to respond. The Section 19 duty in terms of the Children and Families Act to have regard to the views and wishes of the child or young person and their parents, that still applies. So that doesn't mean that children, young people and parents are shut out of the process. They certainly shouldn't be, and need to have regard to their views, wishes and feelings. The rights of appeal to the Special Educational Needs and Disability Tribunal are all maintained. I said earlier that there might be delay in getting those rights of appeal through, but the right of appeal still exists, and the information that's to be required as to your right to appeal and the timescales for doing so continues to still be needed. The information that when you're going through a needs assessment needs to be obtained is exactly the same. There's no change to that. We're still looking at holistic assessments. There might be some delay in getting that information, but we're not limited in the scope of information that we should be getting. The same with taking all that into account when making a decision, either to secure a needs assessment, issue an EHCP or cease to maintain an EHCP. That all stays, as does the form and content of the EHCP, so no change to what needs to be provided by a local authority when it is completing the duties that it must do as soon as reasonably practicable. And there's no change to the age limit for EHCP, so they end in the academic year in which a young person turns 25. So that's the absolute limit, and the guidance from the government yesterday suggested there wasn't going to be any amendment to that time limit, as I know some people had been asking about. And importantly, if it's not explicitly addressed in the amendment regulations, then it stays exactly as it was. So, unless it's there, and unless it's one of the pieces of information that I set out on the previous slides as to where timescales are changed or duties upon local authorities or other bodies are changed, then it continues to exist as it previously did, and there's no reason in law why local authorities can decide not to comply. When we're thinking about delays and as soon as reasonably practicable, I think it's worth having a look as well at paragraph 9.43 of the Special Educational Needs and Disability Code of Practice. And this is about communication of delays and minimising delays within the law as it stood before the 1st of May. There were circumstances where there would be delays and that would be lawful, including, for example, that somebody would be out of the area for a period of time, which would mean that an assessment would not be possible. In those circumstances, the local authority should look to keep delays to a minimum, and as soon as the conditions that had led to the reason for not being able to comply with any set time no longer applied, then the local authority should endeavour to complete that process as quickly as possible. And so that I think is important as we're thinking about this now, because I'm saying we can't have blanket approaches from local authorities, and they need to be looking at the specific conditions that apply. And so I think paragraph 9.43 is important to take into account when doing this. And as we move forward, once the coronavirus exceptions cease to apply, the local authority can't delay further because of delays during this period. So the original timeframes and decision deadlines will then kick back into effect, and unless the government issues some amended regulations. So we'll therefore, after the 25th of September, as it currently stands, be back to the normal way of working, if you like. So that was just about the regulations and the changes that came in there. One of probably the more controversial changes that the Secretary of State for Education has made is the notice to alter the Section 42 duties in terms of the Children and Families Act. And before this notice, and the first one came into effect on the 1st of May, and we're on the third one now, covering the month of July. The duty on local authorities and health bodies was that they must secure the specified provision for the child or young person. So that's the provision in Section F for a local authority or Section G for a health authority. The modified duty is that it must be treated to be discharged if so that'll be the local authority or the health body has used reasonable endeavours to discharge the duty. And so that waters down the duty. It's not an absolute duty as it was, but it's a reasonable endeavours duty. So we need to think further about what that means. But it is time limited. So it covers the month of July at the moment, and the guidance yesterday that was published suggests that there's no intention on the part of the government to extend this period further. There is some consideration within that guidance that there may be a need for localized amendments. So, you know, at the moment, of course, we've got Leicestershire in a sort of as a further lockdown beyond that which other areas have, and so there's a consideration here from the government that they might in the future need to alter duties in relation to certain areas which might be consistent with this modification duty, but it's not intended, at least at this point in time, for it to be a national modification. And that's got to be helpful for people who are, you know, being told that their child or young person needs to go back into education from the autumn term, that the Section 42 duty to secure that provision will then apply is an important consideration for anybody when thinking, you know, about their child or young person attending and making sure that they're going to get the education support that they need. So in terms of the Secretary of State's notice, the Secretary of State considered it was an appropriate and proportionate action in the circumstances relating to the incidence or transmission of coronavirus. And again, we see that incidence or transmission of coronavirus as with the regulations. And so although the third notice recognises that SEND teams' capacity is now greater than at the start of the outbreak, and I think, you know, that has to be accurate as everyone's getting used to this way of working, it's not possible for local authorities and responsible health bodies in England to fully meet their duties under Section 42 because of reasons such as reduced staff or children and young people not being able to attend their educational setting. And so that's part of the reason that the Secretary of State has considered it's appropriate to modify the duty. Considerations were given to alternatives to modifying that duty, including could the provision be delivered remotely at home? And it said that whilst this may be partially successful, it would not represent an effective alternative. And so that even if there's a remote equivalent provided, it wouldn't be exactly what was specified in the EHCP. And I think, you know, in lots of circumstances, that's probably right as a principle, but that's, you know, then leads us to consider, well, how do we secure that that provision and take the reasonable endeavours to do so? And it might look different, but that doesn't mean that no provision should be provided whatsoever. And so the modification is considered to be proportionate because it allows local authorities and health bodies to adapt for their specific area based on the demands that are there, and arrange alternatives as well. And that includes such as delivering therapies remotely or using video. So, you know, just because there isn't an absolute duty to secure a therapy provision that's in the either in section F or section G doesn't mean that it can't be done entirely, and that's what the Secretary of State's notice recognises. And it's very clear that the notice does not absolve local authorities or health bodies of their responsibilities at all, so they can't just refuse, or just ignore their duties in terms of section 42. They have to use their reasonable endeavours to secure or arrange the provision, and that will vary, case by case, and there's no, one size fits all solution for this, but we need to then look at what are the reasonable endeavours in an individual situation as to whether this notice is being complied with. The guidance includes that local authorities or health bodies should keep a record of the provision that they decide in terms of what they should secure or arrange, and confirm what they've decided to do and explain the reasons for that. And I'm not sure whether that is happening. So what's being done differently and why, basically, we need to know, and keep that under review, because there may be changes in circumstances that mean that what was not possible one day might be possible another. So, just because it's not possible today doesn't mean that come next week, if staff are available or if somebody's able to go into an education setting when they haven't been able to before, that the situation remains the same. So it's keeping under review any modifications so that the reasonable endeavours duty is being properly applied. And so there should be a focus on the provision that the EHCP describes, the availability of those who deliver that, and what is needed or what can be done to deliver the provision differently. And so we just have to be a bit creative about what can be done, and to secure that as best as possible, using the reasonable endeavours. And the guidance provides a framework for thinking about reasonable endeavours. So say it's specific, and so that's the question of what is the different provision to that stated in the plan. Where could that be delivered? Could it be delivered in the same place, or could it be delivered somewhere else? How could it be delivered? So is it the timing of it? Is it the frequency? If it's specified as daily, but the child is not potentially in school daily, is only there, maybe once or twice a week, well, that can be modified. When can it be done? So the method can alter. Could it be virtual rather than face-to-face? Can we use smaller groups? So again, these are demonstrations that the guidance thinks that there needs to be some creativity about what happens and by whom. So if there's not the specialist therapist or teacher available, there's somebody else who's able to secure that provision. Even if it doesn't look exactly like it did before, that doesn't mean that somebody else might not be able to deliver that provision. And so if we're not asking these questions in terms of securing provision, then arguably we're not complying with the reasonable endeavours duty. And so that can be used to ask local authorities as to what they're doing and to hold them to account at this point. So again here, consistent with the regulations that are amended, there's not a blanket prohibition on provision being delivered, and so it's individual decisions and making sure that this is being used, the reasonable endeavours and duty is being used to arrange provision as best as possible, basically, at this stage. The guidance provides many examples of alternatives, and I've listed them on the next slide. So that demonstrates again the level of creativity that might be possible. We can look at remote delivery of therapy and alternative methods of delivering therapy. And whilst the guidance recognises that in many cases it's not possible to deliver the provision specified, that doesn't mean that it's the case in everybody's circumstance. And so there may be circumstances and cases where it's absolutely entirely possible to secure all the provision that is currently in section F or section G, because there's actually been no real change in the circumstances. Everybody is still available. The child or young person is still able to attend their placement. So it's not a guarantee, if you like, that no provision will be delivered in accordance with with Section F. It's just looking that in most cases, or in many cases, it won't be possible. As I said before, position today does not automatically mean it's the same as tomorrow, and we need to think about changes in circumstances. And I thought the examples of alternative arrangements were quite interesting, actually, because particularly many people who I represent have difficulty maybe getting the right provision, and sometimes with children and young people not being able to attend school setting in the I suppose the usual way, if you like. And so here considerations of what else can be done and what the government thinks is possible provide a useful insight into how we might be creative about getting provision to work. And this can include things like part-time timetables, temporary placements, adjustments to home to school transport in line with altered attendance times, reduced class sizes, video classes, specialist teachers providing advice and support to parents, educational psychologists providing brief therapy interventions and speech and language therapists delivering sessions via video link, or occupational therapists or physiotherapists doing video link to the children's home, and counselling and CBT delivered over the phone, and loaning parents school equipment. So lots of different ways that can be used at this time to make sure that whilst the child or young person might not get all of the provision that's set in their EHCP, there's ways that we can go about trying to secure that, you know, in the best way possible at this time, so in terms of the reasonable endeavours. And as we move forward, these examples of how to be creative about using provision and securing provision might be something that people want to come back to in the future, in terms of thinking, well, you know, what worked well and should we modify provision going forward. So in terms of transition, as we know, this time of year, many children and young people, particularly those in a phased transfer year, are preparing to move to a new placement. The current time, the guidance doesn't have any specific duties upon local authorities and schools about transition. The government guidance that was included on the site, so the Supporting Children and Young People with SEND in preparing for a wider opening, identified that they encourage settings to provide additional support to pupils with EHCP about to make a transition to another setting or into adult life, and that's of course entirely sensible and hopefully one that schools or other placements are trying to put into practice. And the guidance also identified that if it's not possible to bring back all children and young people for whom a return would be appropriate straight away, then settings may want to prioritise attendance for those who are transitioning into a different setting or adult life, particularly where multi-agency work is required. So whilst there's nothing in terms of what the guidance says about anything, you know, that must absolutely be done, these are recommendations as to what could be considered and how we help people move from one setting to another, particularly those in the phased transfer time who are about to leave the school that they may have been at for a long period of time and need help preparing for this. And the code of practice, which still applies, says that to support transition, schools should share information with the school, college or other setting the child or young person is moving to. So the expectations upon schools to provide information to help children or young people move to their next setting and share that information as part of the planning process continues to exist, and that's of course very important at this stage. And even more important, I would say now that we know that the expectation is that people are to attend full time from September. So for me, as it stands, there were just some considerations I had about, you know, what the current circumstances might mean as we move forward. And so my considerations first is, I sort of touched on before, is will there be an increase in education otherwise than at school packages or options for this? the guidance has identified different ways of securing provision. And so children who are often classified as school refusers, or for parents who are struggling to find a suitable school and their child or young person is not getting provision, well, the government has demonstrated that there are different ways of securing provision and being a bit more inventive about how you might do that. And I think the schools and local authorities are responding to that as well. So that just because something has always been done a certain way doesn't mean it needs to continue, and the examples of how provision might be delivered could be something that we look to rely on as we think about future packages of education. I queried whether there be a change in approach to non-attendance. So there's the in terms of section 444 of the Education Act, which is the requirement for attendance at school, there's a reasonable justification defence, and that's sickness or any unavoidable cause. And so as the situation with coronavirus changes almost on a daily basis at the moment, we'll consider, well, what is there any reason that that somebody's not attending school might have a reasonable justification defence. So sickness, of course, will always be there, but any unavoidable cause may also be related to the coronavirus. And so whilst the expectation is that people will be attending, if they're not able to attend because of maybe they have difficulties with anybody who might be wearing a mask, which has certainly been the case in if there's anybody within school who's doing that, or if they're kind of very vulnerable and concerned about going into school, well, is that an unavoidable cause? And we also need to think about the Equality Act as well. So schools being required to ensure that people can come in full time, does that mean that everybody must go in full time? Well, we'd say the starting position is yes, but if there needs to be reasonable adjustments as well to consider, well, could somebody attend part-time in a way to gradually increase their attendance because they've been out of education for a while and aren't used to attending school? Well, how do we use the Equality Act there to identify ways that we can make reasonable adjustments to build up and be able to attend on a full-time basis eventually, but maybe not immediately? And will that, of course, then be appropriately recorded so that we avoid any concerns about non-attendance proceedings in those circumstances? There might be judicial reviews against any local authorities or CCGs applying blanket policies. Obviously, I've said there can't be any blanket policies. That's not what the law allows. And so if any of those are implemented or demonstrated, then we need to address that. Remote hearings for tribunals. I've not covered the tribunal in the slides today, but the tribunal has shifted from attended hearings or paper-based hearings to also include remote hearings on the video platform, and that seems to have been broadly quite successful, certainly in terms of moving lots of appeals through the system, which were otherwise being backlogged because of lack of court time. So now the tribunal has three potential ways as we move forward of deciding matters. And so, from my perspective, does that mean that we'll be able to increase the speed the tribunal makes decisions, and obviously then the access to justice that people have, and ultimately being able to secure the provision that's required, because the delays in terms of getting a tribunal decision where there's a dispute still with the local authority ultimately affects the child, young person and the family. And so if there's a way around that, and there's a possibility maybe to opt into a video hearing, well, will the tribunal look to incorporate that into its future work? In terms of the age limit for EHCPs, it doesn't look like that those are going to be extended, but will there be fewer cease to maintain decisions, either this year or the next academic year? That's quite possible, as people maybe are, if you like, catching up, or have certainly missed out on quite a long period of education. Certainly those, towards the end of their education, preparing to move into adult services and out of education, well, do they need some additional time to do so? Would any child be decoupled, if you like, from their current academic year because they've missed so much that they need to repeat the year? Is that something that needs to be considered? And my question, as it was on Wednesday, is will we be back to normal after the 25th of September? And the government appears in the main to think that we're going to be back to normal from the start of September in terms of children attending, and with the enforceability of the Section 42 duty. So then we'll hopefully move back to the regulations all coming back into effect, and EHCPs being completed in the normal time frame, and annual reviews being reinstated in the on the every 12-month basis. So hopefully we move back to a situation where what was happening before in terms of what was working well continues, but will the normal now be different for the reasons I've identified about how provision can be secured? Just in terms of social care, there's been no change to the children's social care duties. A child in need is still a child in need. The duty to assess continues to apply, and the duty to provide services continues to apply. And so whilst there may be difficulties in securing some provision for obvious practical reasons in terms of the duties as they stand in law, there has been no amendment to this. There have been amendments in terms of other duties which has been challenged in the court, so certainly led by Article 39, but those of course would be a whole other presentation in themselves and not covered today. Adult social care, the changes on those depend on the individual local authorities implementing any care act easements, and so what local authorities have to consider is whether they need to implement any of the care act easements because of the coronavirus, and so they need to be making that decision in a proportionate way to the circumstances of their particular local authority. Now, as it stands at the moment, there was only one local authority when I was writing these slides operating easements, and therefore the care act duties would continue to apply in all other local authorities as they did before. So we shouldn't be looking at seeing care packages, reduced because of coronavirus. Packages of care still need to be based on eligible needs, and provision is still required to secure them. So hopefully there aren't, too many changes there, and certainly if there are, temporary amendments to how provision is being delivered, then this certainly needs to be addressed and going back to what the law says as quickly as possible. So I'm just going to look at some questions we have received, and I'm just going to have a look at those right now. So I had a question from Kathy. Does the school still get the EHCP money from the local authority even if the child isn't in school at all? I don't know, is the answer. I would expect so, because the placement will be funded. Now, what that means in terms of what provision should be delivered and will be obviously specific to that child, but and there might be ways that the school needs to think about how to deliver provision in a different way, or if the local authority needs to deliver provision in a different way. But in terms of the funding streams and how local authorities and schools are interacting on that, I don't know what any individual decisions have been made about those. So we did have a question about private reports as well, and schools not accepting the private reports and the recommendations within that. And that's something that actually happens a lot of the time anyway, and there seems to be a misconception quite often that private reports can't be taken into account, only stat body reports can be taken into account. There's no reason why private reports can't be taken into account. Their information is relevant to understanding a child, and certainly, some private reports, the people who are commissioned to provide those may have had far more interaction with the child or young person than any stat services. So it's about considering, how to use that report, and so firstly, no blanket refusal on using those reports. And as a further consideration for me, if you were to go to a tribunal and you were in terms of trying to secure some provision that the school or the local authority were resisting, and you were to present the private reports to that tribunal, they would take those into consideration. They would, look at what the report says. They'd work out, how much knowledge the person had who was writing that report and whether they were qualified to write the report they'd written and provide the recommendations they had. And then they would look at how to implement that. So, any consideration that private reports simply aren't given consideration for me is not correct. Just to see, and I don't know if I can throw to Catherine to see if we've had any other questions from anybody whilst I've been talking.
Thank you, Stephen. But yeah, there's one more question just come in. Thank you, Tor, for your question. Is there any guidance for those children who have EHCP and have been shielding if full classes go back and they won't be able to maintain the recommended 2 metre distance? Would they have to provide alternatives?
Okay, so there's a whole raft of new guidance that came out yesterday, and I will need to go through it all in detail to work out what's included. I know the government was talking about bubbles and working that way. There is specific guidance for special schools and guidance for other schools. So I can certainly have a look at that and then come back to you, because I said I haven't had a chance, unfortunately, to read it all at this point. So much came out yesterday. But I do think it's worth having a look on the government's website and having a look specifically at the guidance that's been published for schools, so that you can familiarise yourself with that if you get the opportunity. And I say, if we can find that, I'll certainly feed that back to you through Catherine.
Thank you, Stephen. There was a few questions. A list of pre-questions. So we've got a question from Julie. What are the obligations on a current school to provide support with transition to a new school named in the HCP from September, before, during and after the school holidays?
Yes. Okay, so I put a slide up to cover transition, and the duties in terms of that are effectively the same as they have been. There's been no amendments to those. I appreciate that certain schools will be better able to comply with those duties than others, but certainly they need to be providing that information to the new school or the new setting, and working with the new school. And then I think we also need to be thinking about if there's anything in an EHCP that specifically addresses how transition should work, because whilst the reasonable endeavours duty applies in terms of section 42, if there needs to be work in terms of how a transition should be managed, I think we should be turning to that section F there and seeing how that can be implemented, either in full, as the guidance still encourages and allows for, or if it can't be done absolutely in full, what is the modification to that that's going to work in the circumstances based on when school, when a new placement would be open and who is available within that placement in order to help receive the information and prepare that transition. So if there's nothing in section F, then we're obviously just turning to the code of practice in terms of the sharing of information and the guidance in terms of schools, making sure that children and young people who are looking to transition are really in the priority for people being able to go into education and go into their setting, so that they're helped prepare. And obviously that's going to be beneficial for them if they're not then moving from maybe having last been in school in March, then in September moving to an entirely new setting.
Thank you for that response, Stephen. I've got a question just come in from Sarah. We have applied for a EHCP for my daughter, which was likely to be delayed as the Ed Psych is unavailable to go into school. who is responsible for providing for her needs in the meantime?
Okay, so in the meantime, so the general duties, so the duties on local authority to secure suitable full-time education, and those duties continue. And then there's duties on schools, of course, to provide the support and use their best endeavours to secure special educational provision as well. So we use those duties. So the section 19 duty in terms of the Education Act 96 for local authorities, and Children and Families Act, and then also thinking about the Equality Act as well. So, you know, what provision is required in order to make reasonable adjustments and prevent any discrimination from occurring. So there are, whilst an EHCP is not there and there isn't the enforceable provision that you would have from that perspective, there are still those duties in combination that need to be looked at. And so firstly, we're going to look at the school. What reasonable adjustments can they make? What provision can they secure in order to be able to enable your child to be able to go into school and have the needs met? So that's the same as it's always been, effectively, and that's a duty that existed, say, before these amendments, and will continue to exist after that. And those to be worked in conjunction, so that local authorities and schools simply just don't say, well, we can't do anything until there's been an assessment. We still need to be looking at what adjustments can be made to make provision work, and if that requires some sort of variations to the timetable, if that requires other adjustments that are reasonable adjustments in the circumstances, then certainly those need to be taken into consideration.
Thank you. I think there was a couple of other questions. There was one from Donna. Do children have to go back, and if so, full time? I think some of that's probably been covered, but
yes. So I covered this when I was talking, but the expectation is that all children should be able to go back full time, and certainly, as a starting point, that has to be right. We certainly wouldn't want any children to miss out on education if they were able to go back, but with the considerations that are given as to non-attendance, so any the justification that I was talking about before, and thinking again about reasonable adjustments. So do we need to modify the timetable for them to be able to go back and increase their attendance? Is that something that needs to be looked at? Is the child well enough to go back? There might also be sort of, aside from any coronavirus related reason to not go back, the impact of going back full time after being out of education for a long time might be quite significant, and so whether there's any medical evidence that needs to be provided as to justify why you're not able to, or the child or the young person is not able to attend immediately on a full-time basis, might need to be considered. And this is all things to discuss with the school. The schools need to be making arrangements for people to go back full time, but I think that to be reasonable, they need to be looking at how to adjust that for children for whom that transition back to full time immediately might just be too much, and work a way through to be able to get them to build up to full time as quickly as possible.
Thank you for that. I think there was one more question, unless there's any more coming through on the Q&A. And obviously we've talked about the fact that they're being expected to go back full time, but this question may follow on from the fact that if they're not initially going back full time but doing a phased return, is can parents get support, tutoring resources from the LEA to support home learning, or would they expect an HCP children to be going in full time?
Okay, so absolutely, there's no reason why it should be impossible to get support for education otherwise in the school, home learning, in the interim. I mentioned the section 19 duty and the duty to provide suitable full-time education. If there isn't a possibility for the child or young person to be able to go into school immediately, and we're looking at the reasonable adjustments, this can absolutely include consideration of how support can be put in place at home. What I would say is that if there is likely to be a substantial change in the provision that's going to need some sort of consideration as to, you know, how long that's going to take effect for, and what that might look like, is whether there needs to be an annual review, interim annual review held to consider any modifications to Section F, so that there is a legal entitlement to that provision. And so, yes, whilst in practice and in principle there is no reason that support and tutoring and resources can't be provided, if we're looking at substantial changes to an education package in order to support home learning for a period of time, and we obviously don't know how long that period of time might be for any individual child, then I would suggest that consideration of an annual review is an appropriate step at this point.
Thank you, Stephen. Has anyone else got any more questions? There's nothing on the Q&A at the moment. If not, then I think we're probably ready to start thinking about wrapping up the meeting. Was there anything else from you, Stephen?
So I just wanted to flag up that Irwin Mitchell has the coronavirus hub, and the screens on the slide on screen at the moment is that. So if there is any information that you're looking for in relation to various legal topics, you can access this, and that will be updated regularly, including with education and social care advice.
Great, thank you. And if everyone could remember to fill out the feedback form, and if they've got any questions, they can obviously email the events email at Irwin Mitchell, or our own email address, which is admin@jigsawthornbury.org.uk. And we will be sending out the information on the Irwin Mitchell's coronavirus hub to our members as well, so that you have those to be able to follow up. And I'd just like to thank you all for attending the event, and also a big thank you to Irwin Mitchell and the team for hosting the event, and Stephen for presenting lots of useful information for our members. Thank you, everybody.
Thank you.